Okay, we're going to start off with our first presenter this morning. Our first presenter is Tom Issac in Castles Brock, and they'll be doing a report on the Minister's Special Representative report on Section 35 of Métis Rights and Reconciliation. Mr. Issac, you here?
Thank you.
Flip down there. Okay.
So, good morning, everyone. It's a pleasure to be here, and particularly a pleasure to be able to speak to you about the report that the Government of Canada released in July that I had the honor of being able to write after meeting and discussing Métis rights, Section 35 issues and concerns with all of you. So I'd like to thank all of you for being so helpful to me in carrying out that task, and I mean that very genuinely. As I noted in the report, I was truly impressed with the expertise, the acumen, and the depth of so many Métis governments, institutions across Canada, and it was very, very impressive. And I'll talk a little bit about a few of them. Although I've got to remember, I don't want to single out anyone, or else we'd be here all day if I were to go through everybody that I met with. But so I'd like to talk about a couple of key themes. I don't plan on going through the report page by page. I assume most, if not all of you, have seen it. I called the report a matter of national and constitutional import. And for those of you who read the report will know that that's a direct quote from the Supreme Court of Canada. When they were describing, the unanimous court describing the importance of reconciliation with the Métis, they described it as a matter of national and constitutional import. And I thought, what a better title for a report on the two aspects of the mandate that I was given, one being a process to move forward for the Government of Canada on Section 35 rights for Métis, and what to do with the declaratory judgment from the Supreme Court of Canada and the Manitoba Métis Federation decision. So I'll just give you a couple of comments on the mandate itself. So I remember when I got a call asking whether or not I would consider doing the particular job, and I was a little surprised, just given that it was the Government of Canada calling, because typically we've seen the Government of Canada historically steer away from dealing with Métis issues, and I think it showed a lot of leadership. And I was genuinely surprised when they told me what they were thinking of doing, and I believe almost immediately accepted, given the historic nature of the mandate. And by historic, I mean Government of Canada wanting independent counsel and advice on how to move forward with Section 35 and with a declaration against the federal government from the highest court in the country. And of course, I was further delighted when the current government reaffirmed my mandate, and was grateful for that, because I thought, as I was getting into the work and meeting with all of you, I realized just how important the mandate was. So mandate was twofold. One, I was asked to provide recommendations for Canada on how to move forward on developing Canada's Section 35 Métis Rights Framework. So that mandate was really about providing advice around a process. And I'll tell you right now, I don't believe that's rocket science. I believe very strongly the processes should be very inclusive and very broad-based, no predetermination of who is and who is out, who is in and who is out, because that's a different issue. It's about making sure that everybody has their voice heard, and I did the best I could in terms of reaching out to as many people as I could, and that was my advice. Now, the reason I tell you that that isn't rocket science, what I mean by that is the process that the Government of Canada needs to go through. We need to engage in that, as I suggest in the report, immediately. I don't think there's a need for a delay. We know who to talk to. Many, if not most, are in this room, likely. So the rocket science part of it, of that first part of the mandate, I'll get to Manitoba Métis Federation in a minute, was that in my instructing letter and certainly in my discussions with both ministers, there was the first minister and of course now Minister Bennett, they both reiterated the same theme to me. Well, actually two themes, and I will tell you about both themes. A, you're independent. That's always good to hear and have reaffirmed. And a genuine desire to get advice. I have to tell you that from both ministers. Genuine desire. But the second piece around the mandate, or the second component of this, was the focus on reconciliation. So it wasn't just about giving advice on, well, what's a process look like? It's a couple days. I mean, you know, within a few hours of meeting with most of you. I mean, not, again, I'll suggest to you, I don't think that that's terribly provocative. But when the minister said, with the objective of achieving or bettering reconciliation with the Métis, now we're in rocket science territory. Because whatever recommendations are given on process, we have to ensure that they further the objective, excuse me, of reconciliation. And from my point of view, that was challenging. That remains challenging, and you know that better than me. So I wanted to just tell you that little angle on that part of the mandate, because again, in some ways the mandate was, you know, very restrictive, and I don't mean that as a critical comment. You know, it's not up to me to determine what the mandate is. It was still an historic mandate in terms of a process to move forward, but it was this hook to reconciliation. And for me, that was extremely important, and I would say quite wise on behalf of the government. And again, I mean that very genuinely. I think that there is and was a true desire to try to do the right thing based on the evidence in my meetings that I had. The second part of the mandate, while related to the first part, was really quite distinct and extremely important as well. And it dealt with the 2013 Supreme Court of Canada decision in Manitoba Métis Federation, a decision of critical importance to Métis in Manitoba, of course, but quite frankly to Métis in the rest of Canada, given the importance of that case. And as I was saying at a conference a couple of weeks ago, a decision that's critically important to all Aboriginal peoples. There is a perception sometimes that, thank you, there's a perception sometimes, I'm surprised at how little the MMF decision gets discussed outside the context of Métis. It is the single most important decision from the Supreme Court of Canada on the honor of the Crown. And I'm surprised that we don't see it more being used in litigation by First Nations. There's probably a reason for that, and I'll talk a little bit about that issue in a minute. But it surprises me because it's an immensely important decision. It is among, in my view, the most important decisions in Aboriginal law today. And certainly on the same ground as Chilcotin on Aboriginal title. There's no question. And so a great service was done by the Métis in that litigation that went far beyond the boundaries of Manitoba, and with respect, by the way, but far beyond the Métis, and really went to the core of what 35 means in terms of the court's discussion of the honor of the Crown. Well, I'm not here to talk about that today, but I wanted to say it because it's part of that second aspect of the mandate, and that was to look at the declaration from the court, and the declaration was what? The federal Crown breached the honor of the Crown in implementing Section 31 of the Manitoba Act and the provision of 1.4 million acres of land to Métis children. That was it. 2013, really no movement on that file from what I gather, up until very recently, and some terrific news, and I'm sure you've all been briefed on it, and I'll leave it to others. I believe you're getting a bit more of a further briefing on where that is at, but of course now an MOU signed between Manitoba Métis Federation and the Government of Canada. Very, very exciting. But I was asked to give some advice on what to do with that declaration, and I have to tell you, that was probably the easiest part of the mandate, other than the process for 35. The second easiest, because it was so clear. And you'll see in the report, I actually don't have to spend that much time. And by the way, that is meant as a compliment to the clarity that the Supreme Court of Canada provided, in my view. I tried to make the report as punchy as I could, rather than, leave it up to other experts to describe Métis culture. I don't pretend to be an expert on your culture and language and traditions. But when it came to MMF, this was very simple of what needs to happen. And so I'll talk a little bit about that in a minute. And then, of course, we had Daniels come out. And you'll note in the report, I also say that I don't think I need to deal with Daniels, because it doesn't expressly deal with Section 35. My mandate was about Section 35 and the constitutional protection of Métis rights, not which level of government can legislate with respect to you. Now, I don't want to downplay, and again, we were at a big conference a couple weeks ago, and I see a lot of faces that were at that conference, and I'm not at all downplaying the importance of Daniels, but it doesn't deal with the constitutional issue of the constitutional protection of Métis rights. It simply deals with, and I say simply, but it deals with which government has legislative authority to legislate with respect to Métis, which is an important issue, but doesn't go to the constitutional issue of rights. So for the purposes of the mandate, I didn't need to deal with Daniels, in my view. And again, not suggesting it's not important, but it didn't affect the Section 35 rights analysis. So I was appointed in July of 2015. My mandate was reaffirmed in December of 2015, and the report was released in July 2016. I'm nonpartisan, I'm independent, and I attempted to do the best job I could at providing independent counsel to the Government of Canada. And you'll also note that I attempted to provide some counsel to the provinces, even though they didn't ask for it. I felt compelled. And why do I think that was within my mandate? Because the federal government, the Government of Canada, and again, wisely, I will say to you, said the objective of reconciliation. If this was just about the Government of Canada going and doing a process, well, I don't need to mention the provinces. The Government of Canada can do whatever it wants to do. But if it wants to further reconciliation with the Métis, the provinces have to be involved. That's my view. Have to be involved. And if they don't want to be involved, that shouldn't get in the way of what Canada needs to do. And again, I think I'm quite express about that in the report. I will also tell you that in my engagement and consultation, I very deliberately cast the net wide. I was not in the position of determining who is and who is not Métis for Section 35 purposes. It's none of my business. It wasn't part of my mandate. I have no interest in making that determination. I'm not qualified to make that determination, and it would have been inappropriate for me. And I won't get into all the different, whether it was provincial governments, other government entities or representatives, some Métis, some not Métis folks giving me counsel on who I should talk to and what I should discount and what I should give more weight to. And I thought that was inappropriate for my purposes. It wasn't inappropriate for people to tell me that. That's why you engage. You listen to it. But for me, I made no judgment call on a number of the groups, none of whom are in this room, just to be clear. So I don't want anyone thinking that I'm suggesting there's a question about Métis in this room. But I did meet with a number of groups that there's a question about whether or not they would meet the Pauli criteria. But I thought it was important that I meet with everyone that wanted to give a comment on Section 35 Métis rights. So that was really important for me, and I think it enriched. Certainly it enriched my experience, but I think it enriched the report ultimately at the end of the day. So let me talk to you about sort of these principles. I mean, the key principles that I would focus my comments around are A, recognition, B, reconciliation, and I've been debating about this third one, but I'm going to call it, it might surprise you, but I'm going to call it the public interest. You might say, that's odd. We're going to talk about the public interest to a group of Métis leaders about a report about Section 35 Métis rights. And the reason I want to talk about the public interest last is those of you who read my report, you know that a number of times in the report I talk about the public interest. And I genuinely came to the conclusion that this isn't just about Section 35 and just about the Government of Canada. This is actually in the national interest, that we do the right thing. And I really mean that. And so I dedicate I'm going to just talk a little bit about why I talk about the public interest. So let me just give you a few comments about recognition. And I'll be very blunt and direct about this. On the one hand, we have the reality of Section 35. 60-plus decisions on one sentence from the Supreme Court of Canada in 26 years. Unprecedented. I just put together my casebook on the leading 60 Supreme Court of Canada decisions. It's 1,700 pages long. Think, 26 years. It's unprecedented in the common law that we've had that much intensive effort. So we've got that on the one hand. And yet, what have we got on the other hand? We've got a fundamental lack of knowledge in Canada on Métis people, on Métis rights, and the meaning of Section 35 relating to the Métis. And you'll note, what's my very first recommendation? An education program for the Government of Canada. Now, again, I want to be clear. I went out of my way not to pick on the Government of Canada because, A, I don't think it's very helpful, and I don't think it would have been entirely correct. I met with many officials in the Government of Canada that were quite expert on Métis issues, quite sensitive to Métis issues, but I met many more that were quite challenged on this point. So I just want to make that clear. This isn't a blanket, and likewise with the provinces. But we have a fundamental problem in the country right now. There is a disproportionate lack of knowledge. So you could argue this about Inuit and First Nations, by the way, too. But for the Métis, I mean, all I do is Aboriginal law, and so I do have a reference point. I meet with people from all over the world on these issues, and it's interesting. In governments, I was astounded by the lack of knowledge, by people who ought to know, whose job is to know in some instances. And so that's why you see, sort of right from the get-go, I focus a lot on the law, and I do it deliberately because we're talking about 35. We're not talking about economic and social policy. We're not talking about whether or not the federal government can legislate under 9124. We're talking about constitutionally protected rights. So I wanted to make sure I got the law right first and explained what the law was. By the way, I've not had anyone correct me from any of the governments to date. Maybe they will. I'm expecting something at some point. Oh, other than Tom Flanagan. We'll talk about him in a minute. He didn't like the report. I don't know if anybody saw that, but I don't have it with me, but apparently I was going in the wrong direction, but we'll talk about him in a minute. But we've got a series, and I tell you that genuinely my intent in telling you that A is sort of what I learned, what I observed, and I guess that's what I'm here to talk about today. But B, I hope it's helpful to you in terms of understanding that one of the challenges I think you have, and I was speaking with President Chartier a few minutes ago about this, that one of the challenges I think you have is that there's a whole bunch of folks. I mean, there may be folks sort of against things and you know, there's politics and all that kind of good stuff. I'll tell you, and you know better than me on this, but my observation is that there is a significant element out there that simply just doesn't know. Or they think they know and they don't really know. And so that's why in the report I talk about some of the myths. Métis rights are derivative from First Nation rights. False. You all know that. The law is absolutely clear, no debate. But I heard this. Treaty rights trump Métis rights. False. Métis rights are equally protected with treaty rights. No debate, no law to the contrary. When I say no law, I want to be really clear about this. Any decision in the country, including any sentence out of any decision of which I am aware, suggests that. And yet, there are folks, gatekeepers in the various systems, both federally and provincially. I'm not letting the provinces off the hook here, and I heard this. You don't have to consult with Métis on certain issues. False. There's no case law that stands for that proposition. Métis rights are to be treated equally. The duty to consult fully applies to Métis rights in the exact same way as it applies to First Nations and Inuit. There's no debate. And when I challenge lawyers on this, government lawyers, and by the way, I did not have to challenge Government of Canada lawyers for the record. I want you to know that. I didn't. Think about that for a minute. But some of the provincial lawyers, and challenge them, not a word back, because they know the law. Again, we're not dealing with folks who are uneducated or unsophisticated, but there are blind spots. And there may be other things, and I'll leave that, you know, again, it's outside my, A, my comfort zone, and B, my area of expertise of what else is going on here. But the law is utterly clear on this stuff. And there's gray areas in Aboriginal law, I want to be clear. We're not through the first chapter yet in this book. But these things are, these are fundamentally false. There's nothing to support these. And these were common. I heard this from a lot. As I said to them, there's no excuse for ignoring the honor of the Crown. What I heard from a number of the provinces was, well, it's too difficult. We get a lot of pressure from First Nations. And look, I get that. But you can't, the honor of the Crown doesn't have a caveat clause in it. It goes, well, unless it's too tough. If it's too challenging, it's okay. The Métis can suffer. There's nothing in the decisions that say that. And governing is tough. You all know that. And then finally, I have to pick on Manitoba, the government of Manitoba. And some of you, Saskatchewan, this will be of relevance to you as well, I believe. But in Manitoba, they have this thing called the Northern Communities. And by the way, no offense to anyone from the Northern Communities. My intent here is not, my intent is to go after the legislative regime, not the community, just for the record here. So I meet with the government of Manitoba, and they were telling me about how they consult. And these are public governments, but they have Métis and First Nation folks in them. But these are public forms of government in the sense that anyone can vote in the community. And so we were talking about the duty to consult, and I was asking, well, what about the Métis locals? Are they consulted every time? Well, no, we don't have to every time. Oh, tell me a little bit about that. Well, we consult with the Northern Communities, and they're made up of Métis and First Nation members, and in some cases they're not consulting with First Nations. There is no case law that stands for that proposition. None. In fact, there's case law recently from the Supreme Court of Canada that directly says you cannot consult or check off the consultation box with a larger body that happens to have Section 35 rights holders as part of their membership, unless that body was expressly delegated to deal with 35 rights. And I know a number of you are dealing with that issue at a sort of a higher level, really important and very smart, by the way. But the law doesn't support that. So, again, I was quite taken aback by what I observed in some of the provinces and with some of the federal entities that I had met with about, again, a lack of what I would call common knowledge about Section 35, about the Powley test, about how the duty to consult applies to the Crown, how the honour of the Crown applies to Métis peoples, as it does to First Nations and Inuit equally. And so this general lack of knowledge, and you see I'm spending a bit of time on it, because I honestly, out of everything I did in the report, there's no use in us trying to fix all the other things if the folks that you're dealing with don't understand you and don't understand their obligations to you at a fundamental level. And again, I really believe this. I believe, in what I observed, I believe it is an accurate representation of what exists objectively, that there is a significant lack of knowledge. I practice in every province and territory of Canada, so I see it. But two, I believe that my recommendation is correct as the first recommendation. Because you need to know the people you're dealing with know your rights and know their obligations to you. So the reasons for that, again, I'll leave to people much smarter than me. They can figure out exactly what's going on. I do think some of it is systemic in the sense that for the Department of Indigenous Affairs, for 130 plus years, it's had to do with First Nations. And Inuit to some extent, but even Inuit were sort of in their own separate unit. So that I understand. I think that there's also a bit of blinders from, and it's related to that systemic issue. And I'll talk a bit about that later, about the myopic issue. I call it the myopic issue. So the law, I won't spend too much time on this, but again, for those of you who read the report, you know I spend a lot of time on the law, and it was deliberate. Because now I understand, okay, there's this huge gap in knowledge. I'll put some knowledge into the report, and I'll put it in a way that it's, I think I used the term in the report, unassailable, like no debate. And so that was my attempt, was to do that. Whether I succeeded or not, we'll have to see. You may have some views about whether I did a good enough job on that or not. But that was my intent, was to educate. And not so much educate Métis, just for the record. And remember, my report was going to the government. It wasn't going to all of you. I was advising the minister. And so I wanted the minister to know, and certainly the provincial governments to know, what the law was. The Métis have Section 35 rights. They are one of 3 enumerated Aboriginal peoples. They are distinct Aboriginal peoples with a distinct culture that's not derivative from anything. Again, you all know that. I now know that. The Supreme Court of Canada knows that, by the way. Actually, I just have to do this. Sorry, I wasn't going to go here, but page 15. Let me just read this one quote quickly from, you've probably heard it from Jason and other lawyers about 15 times, but I put it in and I bolded this on page 15 of the report. This is from Powley. And I write, the Supreme Court of Canada emphasized the unique and distinct nature of Métis heritage and culture, and importantly, one that is not, and I bolded the word not, dependent upon First Nations culture and heritage. And here's the quote from the Supreme Court of Canada in part. The term Métis in Section 35 does not encompass all individuals of mixed Indian and European heritage. Rather, it refers to distinctive peoples who, in addition to their mixed ancestry, develop their own customs, way of life, and recognizable group identity, separate from their Indian or Inuit and European forebears. And I quote a whole bunch of other stuff in there, too. That's from a unanimous Supreme Court of Canada. And again, you know this already. So we are still in the infancy of understanding Section 35, notwithstanding those 1,700 pages I told you about. And we are very much in the infancy of understanding Métis claims. I mean, I heard firsthand people struggling with the idea in government of, well, what's it mean not to have a land base? How do we negotiate with people who may not, and by a land base, sorry, just to be very clear, what I mean by that is the INAC system centered around reserves and claim settlement, remember, all geared towards First Nations. And that's not a criticism, by the way, of First Nations or INAC and how it that's another discussion. But it is what it is. And so now you're presented with this idea, well, how do we sit down and talk to the Métis? And potentially there may or may not be a land base. And my advice to the government was, well, you just do it. Your inherent right policy contemplates non-land-based self-government. And again, I'm not advocating for no land base for the Métis, just again. But what I'm trying to identify is that there aren't barriers to this. You only create barriers if you want to create barriers. This is only challenging if you want to make it challenging, in my view. And look, in terms of Métis claims, they're going to look different than First Nation claims. But governments need to equip themselves honorably to deal with these bona fide claims. And you know, of course, I mentioned Manitoba Métis Federation. That was the second part of my mandate. Treaty 3 adhesion, the Northwest Saskatchewan claim, the Pastures Policy, the Dominion's Land Act Commission, script commissions. And look, I know the list goes on and on. And so that's why I had a few people note to me, somebody said, I guess I used it 187 times in the report, the moniker Section 35 Métis Rights. Well, that was deliberate. Okay, that wasn't by chance. And the reason I did that is I wanted to connect Métis rights to 35. And it was very deliberate on my part that I kept repeating over and over and over again. So, where did that lead me? Well, it led me, and I'm now talking a bit about the public interest. I'm talking about the third point, but I'll talk about it right now. And that's the importance of POWLI-compliant registries and the good work that all of you are doing on that. And what I say in the report is that it's in the public, forget about your interests, we'll get to those in a minute. It's in the public interest that those registries be properly supported and maintained. And I want to just make another comment. Those registries are very different than the Indian Act registry. I did hear comments, and I don't talk about it in the report, but, well, you've got the Indian Act registry, and now we'll have a Métis. No. The Indian Act registry deals with 9124. It does not deal with Section 35 rights. Think about this for a minute. This is the implications of Daniels now. Daniels reminds us that the test for establishing Section 35 rights for Métis is POWLI. But it also reminds us that the test for establishing First Nation rights is Vanderpeet, not Indian registry, not membership in a First Nation. Now, it's evidence, but the test is Vanderpeet. Think about the implications of that. Anyway, that's another story. And so the registries that you're working on, that is to say those linked back to 35, are of significant public importance and obviously of significant importance to you. And so I made recommendations about supporting those registries, supporting the research that's going on. I visited one of the labs at the University of Alberta and a few other research projects that are going on. this isn't just about you, and I say that with due respect, by the way. It's about Canada. We have a direct interest. These are constitutionally protected rights. We have a direct interest in knowing who is Métis for the purposes of holding 35 rights, and that work should be supported. And as I say, and now I'm sort of getting to my third bullet again, but it's in the public interest. Then we'll talk about your interests. I also, on this point of recognition, and it's really, now I'm moving into reconciliation, you'll note my recommendation 15. And so my recommendation 15 deals with reconciliation among First Nations and Métis. I heard from a number of governments that, oh shucks, it's tough to govern. We've got all these First Nations who, in some instances, and I want to be very clear, in some instances, not in all instances, but in some instances, had a difficult time getting their head around. Métis had to be consulted, for example, on additions to reserve. Well, the law is very clear on that. We talked about the law earlier. There's not even a debate. Zero debate. We'll not tolerate a debate, okay? I start sounding like Trump now. We won't tolerate a debate. But I really won't tolerate a debate. The law is very clear. You have to consult with Métis where Métis rights may be affected by an addition to reserve. Law is really clear, okay? So that's not open for debate. But I get it. It's difficult. It's challenging. But as I say a few times in my report, just because something is challenging is not a viable excuse not to do it. And not when it comes to a constitutional principle like the honor of the Crown, which Chief Justice McLaughlin said in Haida what? It applies to all of the Crown's dealings with Aboriginal peoples. All. In our case, we're talking about Section 35. So I was at the U of S yesterday talking, and a student asked this great question about, well, criminal law, do you think the honor of the Crown maybe applies to the Gladue analysis and criminal? I said, yeah. We're not talking about that right now. We're talking about Section 35. There's not a debate. We could have, there's room for a debate of what the court meant by all of its dealings. I think the court was pretty clear. It meant all. But anyway, the lawyers can all debate that later. We're talking about 35. There is no debate. And so I saw an opportunity for Canada to show real leadership on this issue of reconciliation among First Nations and Métis. And again, for those of you who read the report, you will know that a few times in the report, I bold and italicized the word opportunity. That was deliberate. Because I genuinely came to the conclusion, having met with, again, all of you, and seeing the successes out in the field, whether it was on in Alberta with some of the employment strategies that I witnessed and some of the employment strategies, the economic development. I said, I won't name who I said it to, it was somebody very senior, and I said, I want my tax money to go there. I mean, I was dealing with the Economic Development Corporation in Saskatchewan. I mean, they were just showing me some numbers that defied logic. Extremely impressive, but that wasn't it. I saw it everywhere. A Gabriel Dumont Institute sent some information to my children's school on traditional plants. The teachers were raving on. They had never seen quality like that before. Mind you, they had never taught about Métis people either before in West Vancouver. They now know. And thanks, Bruce, by the way, wherever Bruce is sitting. Bruce very kindly sent some stuff as well. Well, they now know. It's not. And by the way, no disrespect to the Coast Salish either. So, but this is an opportunity for Canada to show leadership on providing resources and mechanisms to allow Métis and First Nations to come together. Because I don't believe government should be in the way of everything. I really, you need to know that. And you'll note that I didn't put everything at the Government of Canada's doorstep. I'm not an apologist for any government or for any court. I don't advocate on your behalf. I don't, that's not my day job. But when you look at the facts, there are opportunities in this country, and we should be availing ourselves of them. And one of the opportunities for leadership that Canada has is to put mechanisms in place to allow First Nations and Métis to sort out their issues in a respectful, responsible way. That's leadership. And the provinces should also participate. Now, this shouldn't be all on Canada's shoulders. This isn't. Look, anybody watching the 91-24 legal developments, the court is moving away from division. It has moved away, sorry, I'll be really clear, from division of powers. This is about the crown is the crown is the crown is the crown. You all know that. You don't have to be a lawyer to know that. Yet I still have debates with some lawyers about, well, no, you know, we won. I heard that from one of the western provinces about Daniels. I won't name the province. We won. And as I described to them, I said, what an impoverished view of federalism. What an impoverished view of Section 35 in the honor of the Crown, and a view that I think is technically, legally incorrect. So I felt very strongly about that recommendation 15. And you might say, well, again, what's that got to do with the notice I haven't talked about the 35 rights process yet. What's that got to do? Well, reconciliation. It's got everything to do with reconciliation. So let me just tell you a little bit about, I'll just give you a few comments. Just on, actually, before I do that, let me just say on reconciliation, one of the observations I made was the myopic views that I saw, narrow views, views where I got a sense of blinders on. And again, I'll leave it to you to figure out why the blinders are there. I think there's a variety of reasons is my sense, but I don't know. But there are blinders. I dealt with so many smart people. In Issac, I met so many great people, and I have to tell you, people that genuinely want to do the right thing, and I mean that. But I also met with folks that are really struggling. So when we start talking about programming, oh, well, we have Métis programming. And so I was, and as you know, I sort of picked on the urban Aboriginal strategy, and that's thanks to some of you. You alerted me to it. But the non-distinction-based programming, and as I go out of my way in the report, I am not criticizing that. It's not my job. I'll leave that to you. If there's a problem with it, you know, fill your boots. In terms of if there's a problem with the actual program. My point wasn't about the urban Aboriginal strategy or the Friendship Center role in that. My point was you don't get to check the Métis box off on non-distinction-based programming. You can check off the Aboriginal box, and I don't mean that in a pejorative way, but this idea that, well, we can have First Nations distinct programming, we can have Inuit distinct programming, and then for the Métis, we'll just put that in with all the general Aboriginal programming. And that's not to say there's anything wrong with the general Aboriginal programming. Again, I'll leave that up to the experts in this room and others to sort that out. But you don't get to check the Métis distinct box off. I mean, that's just common sense. The one example that really jumped out to me, and some of my friends who read the report, they said, Tom, there were 2 recommendations in your report. Actually, one deals with reconciliation. Let me just deal with that for a minute. And the other one deals with this myopic view. Let me deal with the reconciliation one first. And some of you will note that I made a recommendation, and it jumped off the page to, again, a few friends of mine who sort of know me and know I like dealing with big principles. And they're like, not paying to get into Batoche? What was that recommendation all about? Well, you know why I put that in there. Because I thought it was offensive that people have to go pay to get in to pay respects at a gravesite. That's not Canadian. And look, Parks Canada, I mean, there's concerns, well, what about the national parks? Do we have to let all Aboriginal people into every net? No, no. They don't have folks showing up at the door to pay respects to folks who can trace their ancestry back to the very people buried. So I won't belabor that point, and I hope I said that sensitively enough, but I want you to know why I put that in. It really bothered me. But again, my friends noticed, and that's an odd one. Why that? And well, that's why. So let me tell you about the myopic views. Let's just get back to myopic views. So there was a second recommendation that jumped out to my friends that said, it's interesting, you gave a very specific recommendation. And by the way, the Batoche, that goes under reconciliation. It's a gesture, but it's important. But the other one was on the myopic views was amendments to the Indian Act. So as you all know, and I found out, so all I do is Aboriginal law. I didn't know this, that you couldn't have your name removed from the Indian registry. There's no legal mechanism to have a name removed. So some of you will know that there are Métis in Canada who are not First Nations people who are on the Indian registry list. And you won't put them on your POWLI compliant list for very good reason, because you want it to be compliant. And these folks cannot get their names off the list. So I hear this, and A, I'm a little embarrassed that I didn't know about it. Now I've been asking everybody. A lot of people don't know this. Talk about a knowledge gap. So I end up having some discussions with experts in the system, I'll say, on this issue. And the concerns that came back were along the lines of enfranchisement, believe it or not, of future liability of somebody saying, well, I want to stay on the list. Well, remember, the list has nothing to do with 35 rights. Remember, this Indian has nothing to do with 35 rights. Yet you're denying people access to a 35 rights registry. Think about it. You don't have to be a lawyer to figure it. That doesn't sound right. There's also a human dignity issue. Again, and I'll just speak personally, you don't have to agree with me. In fact, I would expect some of you won't agree with me on this, but I found it just terribly offensive as a Canadian that the state can define who you are and you can't have your name taken off the list. That's not Canada. What are we doing? So I meet with the experts. And then I hear the response. So then I say, well, have you ever thought about the human dignity issue? And the room was full of some very smart people and some nice people. And you could almost see, I think, a light bulb go on. And this is what I mean about this. And it's easy to criticize individuals, but this is about a bigger issue. That the system isn't designed to look sometimes at human dignity issues or basic human rights issues. This isn't even debatable. You should have the right to remove your name from any list that the government, you know, whether you're Aboriginal or not, by the way, I would add. That's another issue. But we're not here to talk about everyone else. We're here to talk about Métis. Government has no right to prevent you from having your name on a Section 35 rights POWLI compliant registry because of a piece of legislation dealing with programs and services that aren't constitutionally embedded, that has nothing to do with 35 rights. So that's why that's there. And it's anecdotal, but again, it was one of those, I saw so many things that struck me, and I did not want to put 1,000 recommendations in my report because I don't think it would have helped anybody. And I did want to stay within the strict confines of my mandate. But from a reconciliation perspective in Section 35, how can we prevent people from having their names rightly put on a 35 list because of a list based on policy, ultimately, at the end of the day? The two don't mesh. I mean, it's just wrong. So that's why the recommendation there, and you'll note I use the term immediately. Immediately amend the Indian Act. Enough is enough. And I mean that, and I think it's in the public interest. So programs and services, I've got a few more minutes. Okay, good. Sorry. Feeling better already. I'm just starting to get going here now. So programs and services. So for those of you who happen to see Tom Flanagan's piece, it did go, Issac report goes in the wrong direction. Now, first of all, I want you to know I took that as a compliment. I was delighted to know that Tom Flanagan didn't agree with me on something because I knew I must have done something. I must have done something. I knew I must have done something well. But what's interesting, if you read his, and all joking aside, when you read his piece, he talks about, well, look, Issac's promoting, spend more money. There's not one word in my report where I tell the government of Canada to spend more money on Métis. It's not my job. You have to know where I can, like, that's up to Parliament, Democratic, that's up to you folks. You guys go sort that out with the government of Canada. What I did say was the money that is currently being spent needs to be spent equitably. That's a different point. Of course, Flanagan didn't pick up on that. And actually, if you read the commentary, what is his real issue? He doesn't like the fact the Constitution was amended back in 1982. I mean, if you read the commentary, and actually if you read anything, that's really what's going on. And I respect that. But call it for what it is. It has nothing to do with Métis people or equitable treatment to programs and services. That has to do with, I don't like the fact that we amended the Constitution back in 1982. Fair enough. But call it for what it is. So I did not advise Canada that it has to add more money. Maybe it should. But I didn't say that. What I did say, and I think I said it strongly, I think I did, that Métis must, not should, must be treated equitably by the Government of Canada and actually by the provinces as well. And it's based, that's why I started on the law, on the honor of the Crown. These are all hardwired into our Constitution. And that's why I focused on that. This isn't a matter of policy, in my view. I mean, there's policy decisions that need to be made. I hardwire all of those recommendations into the honor of the Crown, which is a constitutional principle flowing out of Section 35. We know this from the court. And remember what Chief Justice McLaughlin said, in all of its dealings with Aboriginal peoples, let alone Section 35. And my view is that it's in the public interest that Canada and the provinces aggressively look at their programs, their services, and ensure that they are meeting some form of equitable standard. That's not going to happen overnight. You know that more than I do. But it must happen. And it's the right thing to happen. And as I say in the report, this is an opportunity for Canada. And I believe Canada's been quite receptive to it, is my perception. And I don't want to speak for the Government of Canada. It's not my role to speak for the Government of Canada. I know they're still reviewing my report. But my sense is that it was reasonably positively received. And of course, I remind Canada that the name of the department is Indigenous Affairs, not First Nations and Inuit Affairs. Indigenous Affairs. And then some of you, and I actually mentioned the regional offices and some of the issues there. I heard from so many of you. Actually, I heard from the provinces. A lot of Ontario, for example. I remember they were very eloquent on this point, the regional office for INAC. Wanting, talking about their great relationship with the province. But I also heard from some of the provinces in the prairies wanting a better relationship with the regional offices of INAC. So again, these are opportunities. These aren't challenges. At the end of the day, it's dealing with Métis as Métis. Again, you know this already. You don't need me to tell you that. But that's what I took away, and that was my counsel to the Government of Canada. And that's an opportunity. As I state early on in my report, and I did it in summary form because I'm not an expert on your history, so I was a little out of my depth, and I was a little, it was a bit unnerving for me to write about Métis history. I tried, if you notice, I did it as briefly as I could. That was deliberate too. But I mean that respectfully. I don't mean that, but I don't, I'm not an expert. I'm not Métis. And so I wanted to be very respectful and do it in as pithy a way as possible. But what I did say early on is that you are the story of Canada. You know that. So why aren't we celebrating that more? I talk about going back to Batoche, and some of you know my experience there. I mean, I was just so impressed. The Canadian flag and the veterans, the national anthem, everybody smiling and having a great time. We should be celebrating that. There shouldn't be a gap in knowledge of that. Again, you know this already. You don't need me to tell you that. But I got it. And that's thanks to you. But that's what I tried to convey back to Canada. So let me talk a little bit about the role of provinces, then I'll wrap up. Let me just say, actually, on the programs and services front, I do recommend, and there's a number of recommendations about moving away from program funding into block funding, treating governments as governments, putting meat on the bone of the nation-to-nation relationship that I think the Prime Minister very eloquently, and again, I'm nonpartisan, but I do think very eloquently talks about. Well, as I talk about early on in the report, reconciliation must be more than just platitudes. It has to be about action in order for it to be meaningful. And so I make the recommendation that a comprehensive review of existing programs, services be conducted within the Government of Canada to ensure that Métis, as Métis, are being distinctly considered, and that money be spent equitably. Notice I didn't say equally, equitably. So there are judgment calls to be made. But when you're a minuscule amount of a budget, and you're one of 3 constitutionally protected Aboriginal peoples, we've got an issue, an apparent issue. So the role of provinces, and then let me talk a little bit about the Manitoba Métis Federation. So role of provinces. I felt very, very strongly that in order to do my job properly and in order to give good counsel to Canada on how to move forward with reconciliation, the provinces must be involved. And I made a recommendation, again, thank you in particular to the Métis National Council for their briefings on the need for a reinvigorated trilateralism, which I completely agreed with, because it's the right thing to do. And it's good for our country. I've really spoken about, I think, the provinces throughout my presentation, but I will say this. Many of you have your work cut out for you. You know that with some of the provinces. Ironically, Ontario, and I say ironically because I do a lot of work in Ontario, on the First Nations front, Ontario can be very challenging. Ironically, the initiatives that the Government of Ontario has undertaken with the MNO are astounding. And they really jumped out to me in terms of that provincial component. But as I say in the report, these are opportunities for the provinces too. Provinces like Manitoba that could really be and ought to be at the lead, and they've got a wonderful government to deal there with MMF, and take advantage of that. And of course, Alberta and Saskatchewan. I mean, there's so many opportunities, likewise British Columbia, that these are opportunities. Whether or not they'll listen, that'll be up to you to determine. I know that some of you have asked the provinces for their views on this, and I think that's a good thing, to see if you can get public comments on the record about where the provinces stand on the recommendation. So let me just tell you briefly, or from my point of view, on the Manitoba Métis Federation decision and my recommendations. As I said, in some ways it was the easiest part of my report because it was so clear. When I was in Manitoba, I was surprised in dealing with some of the provincial folks that a lot of folks didn't want to talk about the Manitoba Métis Federation, which of course blew me away with the briefings, I should tell you. Very intense. I believe I got a headache well before 11 o'clock on our first day of briefings, and that's a compliment in terms of the intensity and the amount of quality briefing material. And again, all of you, I don't mean to single out MMF on that, but we're talking now about MMF, so I will. But all of you, I mean that genuinely, you all provided amazing materials to me. But I remember dealing with the province of Manitoba, and they sort of wanted to talk about everything but Manitoba Métis Federation. And so when I got to the time to do the recommendations, you know what I wrote.